Good evening, Justice.
How
Good
are
evening,
you?
the commissioners. Okay. Coping.
Okay. You are an attorney.
Yes, Justice.
Since 2003.
Yes.
You did your articles between 2001 and 2002.
Yes, that's correct.
And before that, you had been a legal collections officer in the KZN Finance Corporation
Yes.
for a number of years, 6 years.
Yes, that's correct, Justice.
And you had chartered your legal career with 2 degrees, BA Law from the National University of Lesotho, I almost said Roma, and an LLB from the University of Natal,
Yes, that's correct, Chief Justice.
which is also my alma mater. You have acted as a judge in the KwaZulu-Natal division for a few times, starting in April last year.
April 2021. Correct, yes.
And how many acting stints have you had, and what do they add up to?
They add up to 46 weeks, Justice, yes,
Okay.
beginning from, as you said, April last year. Yeah, up until now.
All right. What kind of work do you do in your practice?
It's commercial litigation, personal injury claims, conveyancing. Yes, basically that's what I do.
And I see that you've said you've handled the whole range, or well, almost the whole range of cases one gets in the High Court. You've done criminal trials, civil trials, motions, opposed and unopposed appeals,
Yes,
even full bench appeals.
yes, I've sat in one full bench appeal.
How many judgments have you, written judgments, have you produced?
Written judgments, I'd say plus minus 30, 35, between that.
Any of them reported?
I'm not aware of any that have been reported. I'm not sure if it counts, if it appears on SAFLI. 2 of them appear there.
Yeah, well, it is reported. I see that you have not yet been taken on appeal.
Not that I know of,
So
no.
one would assume that you're still on the right track.
I hope so.
You have partly had matters. They would have been, you would have continued with them last month.
I did during recess.
Were you able to
those 2
finalize
weeks.
them?
No, I did not finalize it because on the second week, my accused, the third accused, didn't see eye to eye with his counsel, and so we had to adjourn to allow the accused to secure legal representation.
All right, and there's a civil trial that you say has not been set down for a trial date yet. That's a part head?
It is part head,
okay.
yes. Yeah.
You don't have any reserved judgments, you say?
No, I don't.
Okay. You sit in a number of bodies, adjudicative bodies. You chair the disciplinary committee for the National Home Builders Registration Council since
Yes, that's correct,
2018.
isn't it?
And you are also deputy chairperson in the Municipal Bids Appeal Tribunal. And you're a member of the appeal panel for the Department of Economic Affairs, Tourism and Environmental Affairs. You also consider appeals there. And you are a CCMA commissioner.
Yes, that's correct, Justice.
Okay. Wow. You think you're ready to become a permanent judge now?
I believe I am ready, Deputy
What
Chief
gives
Justice.
you that conviction?
Well, throughout my career, I've worked towards joining the bench at some stage, and that is why I've availed myself to serve on those other adjudicatory positions. I believe that they have, together with my experience and qualifications, stood me in better ground to be able to discharge the duties of a judge at a high court.
Yeah. All right. I'm going to hand over to the commissioners to put questions to you.
Okay, thank you.
AJP Madon.
Thank you, DCJ. Mrs. Mlaba, good evening.
Good evening, Justice
Yes.
Mtondo.
So, in the period between 2003 and 2009, did you appear before the High Court on your own account?
Yes, I did on several occasions for applications, not so much on criminal matters, but at the motion court.
Would you say that your appearance was frequent or occasional?
It was frequent, although on some occasions, as I said, I would brief counsel. Yes.
But that would not be in conflict with what you said in your questionnaire, because you say it was occasional.
Can you please direct me, Deputy JP?
No, what is that's what the LSA allege you have said.
It's
I don't
6.1 in your questionnaire.
I don't have it.
Thank you,
Miss
Commissioner. 6.1.
It's court experience.
Yes, I've ticked occasionally.
But now we say it was frequent.
Well, my apologies. I did appear on a number of occasions, yes. And occasionally, yes, I would brief counsel for the High Court appearances.
Okay. The LSA is of the view that despite that you have extensive experience in quasi-judicial environment, labor law, and convention, you still need adequate experience in handling applications of post-motion and trials. What is your view?
My view is that I'm not sure if they are correct. How I feel is that since 2001 in April, when I started acting as a judge, I have had exposure as a judge at the motion court. I have handled several applications, and during that period, I've not had any major issues in handling those matters. I also sat at the Durban High Court, and I believe that the workload there is much heavier than the Pietermaritzburg Court. I'm saying that because while at the Pietermaritzburg motion court you would have plus minus 30 or 35 matters to deal with, at the Durban High Court you would have plus minus 45 matters to deal with, and those would include Rule 43 matters that you do have to finalize on that day. So I do believe that and that's the reason why I wanted to act more, and the reason why I did not apply for the April interviews. I wanted more time at the High Court so that when I do apply and when I do sit, I do so confidently with the knowledge that I can handle those matters. And I'm not saying that I know everything right now, but I believe I do have the potential and with the assistance of the judges in both Pietermaritzburg and Durban, which has been very forthcoming. I have approached judges and they have assisted me where there was doubt on my part. So I do believe that if I am appointed, I will continue to do so. I am ready.
So then, in your own view, your acting stint has given you sufficient exposure and experience that it can be said that you are now ready for an appointment?
I do believe that, Deputy Chief Justice, JP, I do believe I'm ready. And my experience will count, and the exposure that I've had on sitting as an adjudicator in these other panels, I do believe I am ready.
Thank you, TCJ.
Thank you, JP. Premium?
Thank you very much, DCJ. Good evening, Ms. Mlaba.
Good evening.
You're welcome.
Thank you, Acting Premium.
The LSSA, in their recommendation, they're indicating that the extensive experience you have, and they're raising it as a concern, is only on quasi-judicial environment and labor law and conveyancing, which I think on its own is not a problem. Now, I want to know, what do you think your 46 weeks of acting has taught you that you did not get in this platform?
Yes. At the High Court, I deal with issues that do not come before me as a disciplinary chair. For instance, at the NHBRC, applications do come before me that I don't deal with as a panel member or a deputy chair at the municipal bids appeal tribunals. At the court, at the High Court, you deal with different sorts of applications, and you really have to apply your mind in different areas and forms of applications. So, having had these 46 weeks at the High Court, it has exposed me to more issues that I will need to sit and decide and evaluate when I am a judge. It's not restricted only to a particular area of the law, like you would if I sit as a commissioner at the CCMA, where I deal mainly with the labor-related issues. So the area is more vast at the High Court.
Okay. At the High Court, did you have or did you sit for any criminal and civil matters, and are there any that you can remember on the top of your head?
Yes, I have sat for criminal matters. One of the judgments that I wrote, one of the matters that I sat on, is one of the judgments that I've attached in my application, which involved kidnapping and killing of a baby. It was a prominent case, and in my gallery, in my courtroom, I would have organizations and political parties from different political parties, because it had such a public interest. And that's not the only one. The other one that I set, a criminal matter, was for the murder of a retired school principal who was murdered by her gardener. That also created a public outcry. And really, with the assistance of the assessors that I choose to work with, we really, I do believe that I did justice in the handling of those matters. With regards to the civil trials, yes, I have conducted a few civil trials I'm not sure if I did, I don't think I did include one of the judgments for those, but yeah, I've handled civil trials. I have been allocated trials, one of which is still pending. It's part head. It's one of those that I've indicated. I've also, as I said, had arguments on motion courts where I've reserved judgments and then went away to apply my mind and write a judgment on those.
Thank you very much. Thank you, TCJ.
Commissioner Club?
Thank you very much, DCJ, and good morning, Ms. Mlaba.
Good evening, Commissioner.
I'm going through your CV, following the comments made by the Law Society that you appear to have extensive experience in a quasi-judicial environment, labor law and conveyancing, but you appear not to have adequate experience in handling applications, opposed motions and trials. And because of that, they don't support your nomination. Now, that took me to your form, sorry, your questionnaire. 6.1, in fact, 6, court experience. 6.1, you say that in the period between 2002 and 2009, you appeared in court frequently, but in the subsequent years, your appearance was infrequent. I think
Yes,
it's the point that JP Matondo, acting JP Matondo raised.
Yes,
And when we go to 6.2, where you are asked to list the proportion of your litigation work in terms of the fields that are mentioned there, criminal law, of course, you say it's minimal. 6.2.2, administrative law, but you list the experience you acquired, in the quasi-judicial environment. 6.2.3, constitutional law, the same thing, experience acquired in the quasi-judicial environment. Labor law, and so on, and so on. Apart your acting as a judge, and I don't get this thing that convinces me that you are a skilled legal practitioner. I don't get it. I want to take you back to your questionnaire again. During the period when you were on your own, NF Mlaba attorneys, 2010 to 2018, is the period where you appeared in court infrequently. So, and then in 2021 and 2022, since 2021, April, you literally spent all your time on the bench. And again, there's nothing to show that you did anything besides acting on the bench as an attorney. Now, I'm trying to get this thing that will convince me, because I don't appoint you, I don't recommend you on the basis of the stints that you had on the bench. We are looking for a skilled practitioner who has an advantage of having acted. I think acting gives you an advantage, but want a skilled practitioner, and of course, acting stint is an added advantage. It's not the other way around. You know, being on the bench and acting as a legal practitioner being just an additional thing. So I'm trying to get this thing that makes me to say, indeed, on this day, I was part of the GSC that recommended you to the bench. What is it that I would advance as a reason? It then takes me to the next question. What attracted the JP or acting JP to invite you to act as a judge if you have so little to demonstrate, that you are a skilled practitioner? I'm not too sure if I'm trying to, this thing is going through my mind, and I'm trying to sift this thing so that I'm convinced that you are a candidate that deserves to be appointed to the bench. Thanks. It was my question clear, colleagues?
It was, I just didn't like it.
Opinion decision?
No, never mind. I was
Okay.
pulling your leg.
Okay, thank you,
DCJ?
Commissioner.
Yes, Commissioner Singh?
Sorry, if I may just come in just to add to the question and to that very same question. May I?
Yes.
No, thank you very, very much. Good evening, Ms. Mlaba.
Good evening, Commissioner.
I note these what's described as quasi-judicial bodies that you served on. And I'm trying to, in my own mind, place a weight on the importance of those positions vis-a-vis sitting as a judge on the bench. For example, the NHBRC. Now, just as a follow-up to Commissioner Kaba, and just to emphasize the fact that, did you deal with the membership of members on the NHBRC, or did you actually deal with the unscrupulous membership and the quality of houses that have been built by some of these members of NHBRC? And the same can be said for the other body that you served on, which is there's one other body that you described that you serve on, the bids appeal, the Municipal Bids Appeal Tribunal. What was your actual role? So that I can put a weighting and a comparison between that role and sitting as a judge. So I thought I'll just add to what Commissioner Mlaba had said. Thank you. Thank you, DCJ.
Okay, thank you, Commissioner. Just perhaps to start with the latter question. At the NHBRC, I sat there as a chair of the disciplinary committee. My job was to listen to the parties. The NHBRC has their own prosecutors who then charge home builders who have failed to comply with the council's rules. And mainly the two areas which are frequently contravened is failure by the home builders to enroll construction prior to the commencement of that construction. So when a home builder has failed to do that, they would be charged. and they would then be called to appear at that disciplinary inquiry. So that's the disciplinary inquiry that I would chair and make a finding together with two assessors who are experts in construction. The other contravention that they would be charged for would be non-compliance with the building standards that have been formulated by the NHBRC. So those are the two charges that I would hear and then make a finding based on. So my role in that quasi-judicial forum would be to chair those hearings. At the MBET, the Municipal Finance, MBET, the Municipal Bids Appeals Tribunal, their tribunal was set up to assist with the appeals where aggrieved tenderers who were not successful in their tenders would then be allowed to appeal, and they would look at whether or not the municipality has complied with the SCM procedures. Depending on the grounds of appeal, we would look at whether or not those grounds are valid for that award to be either set aside or confirmed. So there I would sit as a deputy chairperson of those hearings. Now, the first question by Commissioner Mlaba is struggling to locate as to where my litigation experience is. I served my articles at a law firm, De Villiers, Evans and Petty. Their specialty was commercial, municipal, and property law. Every day, as a candidate attorney, I would go to the magistrates' court in their applications court. For those 2 years, I think I rotated 8 months in that field. And while doing that, my job was, as I said, appear at the magistrates' court in their applications and also assist my principal in the drafting of pleadings, preparing for trial, and attending court. That would be the litigation experience that I would have gained while I was serving my articles. And then I moved over to Judicial in Peter, and as a professional assistant, I continued to appear mainly at the Pinetown Magistrates Court, the Chatsworth Magistrates Court, as well as the Durban Magistrates Court. And there, their main client was Itala Finance Corporation, and I would then, I was allocated that portfolio and various types of applications. There are various types of applications that I attended to, both at the Magistrates Court as well as the High Court. And then I opened my firm together with a partner, Mlaba in Kumalo, where I also continued with commercial litigation. And there I branched out to conveyancing because as a law firm, a new law firm, we needed more work. And so I studied because I had interest in property law. I sat for the conveyancing exam and I passed, and then with the difficulty of us getting into the panels, my experience in conveyancing was then the private transfers because we were struggling to get into the panels of the banks and the estate agents. So I would not have experience in bond registration, but transfers, registration of transfers. But still, my job was to continue with litigation, and that is when I also got interest in labor, because we got into the panel where we allocated labor work. And also I appeared together with counsel at the Labour Court where we're doing labor relations issues. And that is where in 2009, so that occurred from 2004 up until 2009, where in 2009, I then attended training at the CCMA, and because of the extensive nature of that training, it was 6 months, I resigned from the firm because it would not be fair on my partner, and I concentrated on the training. And as I said, my goal was to end up at the bench. So to me, there was an opportunity to get to the CCMA because as a commissioner, I believe you discharge more or less the same duties as a judge would discharge at the High Court. So I attended the training, I got accredited as a commissioner, and I sat at the CCMA. So and then I reopened the firm NF Mlaba Attorneys because I still wanted not to miss out on the practice. But I must say, during that period, my appearance at court was limited because of the nature of the work that I used to do at the CCMA. I would go to the CCMA maybe twice per week and maybe one other bargaining council, and then I would have time at the office dealing with my matters, and that is why that litigation experience was then reduced to some extent. But overall, commissioners, I would like you to consider my experience from the time I was admitted or even before up until that period, and also taking that into account as well as the stints that I have had at the High Court. I do believe that I am ready to discharge the duties of a judge.
Thanks.
Deputy
Can I
Chief Justice,
continue?
can I follow up?
Yes, Commissioner Nontuthuzelo.
Good evening, Ms. Mlaba.
Good evening, Commissioner.
I just want you to explain, because I think the commissioners need to understand that being a chair of the NHBRC, council appear before you, they raise, it's as much as it's a quasi-judicial, but tribunal, council appear before you, and they raise points in limine. You have to do a judgment. Can you just please explain to that?
Yes, thank you, Commissioner. In all these forums that I sit to chair and also as a panel member, as you know, everyone has a right to legal representation. And so in these forums, the parties would sometimes appear on their own, but in most cases, because issues that are involved, they do believe that they are complex. They do instruct attorneys, and counsel would appear before me, and they would raise all sorts of issues, sometimes points in limine, which you then have to rule before you even get into the merits of the matter. So, as I said, my goal and end goal was to end up at the bench, and so I believe that by serving on those panels, I would gain more experience in adjudication of disputes.
Can I continue? So, do you agree that acting as a judge is of secondary importance?
I agree. It is important if you want to end up in the bench.
And then the last
You would
question,
have to have initial experience before you get to act as a judge.
would you also agree that you come to the bench armed with court experience acquired mostly between 2002 and 2009?
Mostly 2002 to 2009.
Yes,
And also from 2004 up until 2018.
Thank you. I have no further questions, DCJ.
Commissioner Nyambi?
Thank you, DCJ. One question from me. Evening, Ms. Mlaba.
Good evening, Commissioner.
If you can share with us two qualities of a good judge and mainly focus on those that you think you possess.
That I think I possess.
Yes.
Okay. Thank you, Commissioner. A judge has to be knowledgeable in the law. A judge has to have integrity. A judge has to have an open mind. A judge has to uphold the values and the spirit of the Constitution. A judge has to be able to act with integrity, to act and handle matters without fear or favor or prejudice. In order to do that, you need to acknowledge what your prejudices are, so that you are aware when you're dealing with matters that you need to be objective, because if you do not know of what your prejudices are, they may affect your handling of the whatever matter that is before you. I believe that I treat people with dignity and with respect, irrespective of their social status. I believe that everyone is deserving of the protection of the law, and everyone is accountable to the same laws. And I believe, and I do believe that I am a person with integrity, both in my professional capacity and personally. I think those are the important qualities of a judge.
Thanks, Ms. Mlaba. Thank you, DCJ.
Commissioner Balwani?
Can I make a quick follow-up, DCJ?
All right, go ahead, Commissioner Mlaba.
I heard you describing what one would call what characterized a good judge, and you went to town about it. Do you think you fit in all of those things that you just described now?
Thank you, Commissioner. I do believe I fit in most of them. As I said, I was asked to pick two that I think I do fit, but I do believe I fit in most of them. I have the grasp of the law. I do not profess to know everything about the law, and what I do enjoy with the profession that I'm in is that where you are not clear, you do have an opportunity to research, and so that by the time you need to issue a decision or to deal with the matter effectively, then you would be confident that you are able to deal with that matter effectively. I do believe that everyone is entitled to justice, and which is why, and also effective and expeditious justice at that. And that is why I do not believe, or I do not have any reserved judgments. Yes,
You see, the issue, sorry for my interruption. You were asked to give two, and then you went to town and invited this problem for yourself.
Oh.
Now, and answering again now, you create another problem for yourself. You say most of them. Which ones do you think you're not fitting? Of all those, the ones that you have listed. And today we want to finish early, I'm sorry, so that's why I'm interrupting you.
Okay, thank you, Commissioner. As I said, I do not know, or I'm not conversant with all the areas of the law. And that is a point that I need to work on. As to integrity and the rights afforded by the Constitution, I do believe I work towards that, and I do treat people with dignity and respect.
Thank you very much, DCJ.
Commissioner Baloyi?
Thank you, DCJ. Good evening, Ms. Mlaba.
Good evening, Commissioner.
I think when you were answering the acting premier, you said you were not sure if you had included, you were asked about your civil matters. Just to point out that you have included 2 civil cases, Ikubu versus APSA, you have that, and then you have NMI Group versus MEC Public Works. I'm just mentioning.
Okay.
Now, am I correct in my computation of your period as an attorney? I have calculated it to 16 years. Does that sound
Yes,
right?
that sounds correct, Commissioner.
So you've been an attorney for 16 years?
That's correct,
All
Commissioner.
right. And you say you've acted for 42 weeks?
Yes, for 46 weeks, Commissioner.
46, you say. I'm sorry about that. Yes. Now, if you would just explain in what way do you consider that the adjudicative tribunals that you serve in the way that you've described, how that has contributed to your skill, or to give you a skill that you think puts you in good stead of at least starting off as a judge?
Okay, thank you, Commissioner. Sitting in those forums has allowed me to be able to conduct hearings and observe the principles of procedural fairness. I afford parties an opportunity to state their case. That is important. I afford parties to ventilate issues, and I know once that has been done, then I would have enough information that would assist me to make a finding or a determination of the issues that have been raised. It has allowed me to know that whenever you deal with a dispute, what is your job as a decision maker? You need to sift the relevant facts from what the parties may submit, which may not be relevant to the issues that you need to decide on. And you are able to guide the process and take charge of the process, and also to guide the parties when they perhaps give information that is not relevant, without being in a respectful manner, without making the parties feel like they are, really out of what they're supposed to be doing. And then at the end, it has also assisted me to be able to evaluate the evidence that they would have led, and then make a finding based on that.
Thank you, Ms. Mlaba. Thank you, DCJ.
Commissioner Nokis?
DCJ. Ms. Mlaba, I'm asking you this question. Are you aware of the principles set out in Plascon Evans?
Yes, Commissioner.
Can you just summarize?
Okay. The Plascon Evans rule allows a court or a judge to make a final determination of a matter based on the evidence that you would find in the affidavits, even where there is a dispute of fact. because ordinarily, where there is a dispute of fact, the parties would then be asked to lead oral evidence. However, in motion proceedings, where parties give their evidence via their affidavits, the judge is then allowed, in terms of that rule, to make or to finalize or to give a final determination of a matter.
What does the rule say? How do you do that? What does the rule say?
Okay, so where the applicant has made averments or allegations and the respondent does not or admits those allegations by the applicant, and also based on the averments and allegations by the respondent, then the court will feel that it can, even though there is a dispute of fact, make a final determination of the matter based on the averments by the respondent as well as the admissions by the respondent of the applicant's allegations.
If as a judge, in the process, you write a judgment, but in your order, you omit to state, for instance, you want to grant costs for the plaintiff, but you don't write that, you omit and deliver the judgment, only realize later. What would you do to remedy that situation?
I'm sorry, Mr. Nokesa, I didn't hear that question.
You are a judge, you have prepared a judgment, but in your judgment, you omitted an order that we have in the body of the judgment intended to grant, like granting cost order, but you simply don't make that, you don't specify in your order and deliver your judgment. But once your judgment has been delivered, you realize, oh no, I have not stated that costs are granted. The question is, how would you go about to rectify? What should you do?
So the judge would have made an error there, and the rules of court allow for a judge to correct that order without even the parties making an application for that error to be corrected. So you would then, as a judge, vary your decision by an addition of that which you have omitted to put in your order.
Commissioner Marumachai?
Thank you very much, DCJ. Good evening.
Good evening, Commissioner.
You highlighted the plight of women indirectly who are opening their own law firms, and the fact that they are not given the work that ultimately will ensure that at the time when they are judged, they can be judged objectively based on the work that they have done, and I appreciate that. But it appears as if, to some extent, you were exposed to labor law. Am I correct?
Yes, I was exposed, Commissioner.
Yes. I want to ask you a question in that area of law, because perhaps maybe when you get this job, you might be seconded to that court, and the JP of that court is actually here. There is an issue in South Africa in relation to disciplinary hearings, where there is no law apart from one of the schedules that allows people who are accused of some workplace transgression and they are placed into disciplinary hearings for them to be able to bring their own legal representative, right?
Yes.
But employers are allowed to go and seek out somebody who is legally trained to chair the disciplinary hearing. I'm wondering, what is your view, if any, if you have thought about it, in relation to the power play, where the law says, no, you can get another employee or somebody within the organization, but the employer is allowed to bring a legally trained. Do you think there is parity there is fairness? What is your general view in relation to that?
Okay. So, Commissioner, if I understand your question, is the employer is allowed to bring a legally qualified person to chair the hearing, not to represent the employer?
No, remember, the employer is the one who's doing the disciplinary hearing, so it does not
Yes.
necessarily need a representative. I mean, they will just call witnesses. Maybe one of the managers will come and give testimony. I'm just talking about the chairperson of the commission.
As,
I'm sorry, but that's a totally unfair question. And really, it's wrong. I don't think you need to answer that. Through you, DCJ, please.
Yeah.
Thank you.
I'm inclined to agree with you.
Sorry, Deputy Chief Justice, I think it is a question that just elicited a thought.
She's standing for the High Court. If you want to ask her labor-related questions, wait till she applies for the Labor Court.
Judge, I understand that. When you speak, I listen because I respect you. It is just a question, and she can just reflect on it. It's not something that is...
You asking her if it's fair that an employer employs a lawyer to chair a misconduct inquiry. Am I right?
With due respect, Judge President, it is just a question. We will just reflect on it. Thank you very much, Deputy Chief Justice.
I think put the question, let her answer, and we can have this discussion during deliberations.
It's not a question that I will go to war with Deputy Chief Justice. It was just a question based on the experience that she was exposed to. If it can be left alone, then I'm fine with it. It's not something that I was really committed to asking. I thought it was a fair question because of her experience. But I accept.
As I say, if you still want to put it. She'll give whatever answer she has, if any, and we can discuss the merits of her answer during deliberations.
No, thank you very much. I think she understood the question. She was ready to give an answer to it. And if she does, then I'm fine with it. Even in the deliberations, I'm not going to raise it. It's not necessary.
okay, can I proceed?
Yes,
Okay.
Ms. Mlaba.
Okay, thank you, Commissioner. Well, for me, I think there is an employee on this side, and the employee, when it's an internal inquiry, the employee would then be allowed to bring representation. However, that representation must be by a fellow employee who may be a union member, who would somewhat be knowledgeable in the conduct of the disciplinary inquiry. And on the side of the employer, it would perhaps, the initiator or the prosecutor would be a manager who is able to conduct the disciplinary inquiry. The chairperson, it should not, to me, I do not think that it is unfair, because the chairperson's role is to make a finding once the chairperson has heard both sides from the employer and employee. And that chairperson has to at least have basic knowledge, which I think it may be the reason why the employer would get someone who is legally trained, who would understand the process and guide it and conduct it fairly. As long as the chairperson is impartial and applies and gives reasons for his decision and gives an opportunity to both parties to state their case, I think it would be, it's okay, it's in line.
No, thank you very much, Judge. Thank you very much, Deputy Chief Justice.
Any questions from the virtual platform?
Thank you, Justice.
Thank you. Is there a request to put a question? No? Oh. We have reached the end of your interview, Ms. Mlaba. Thank you so much for joining us. You are excused.
Thank you to the commissioners as well. Thank you.